minutes remaining, should he wish to
Thank you. Good
take
morning,
that opportunity. Raymond Ho.
Thank you, Mr. Speaker. The bill simplifies the limitation regime by providing a general civil limitation defence to most claims. A new concept, money claims, is introduced. It is a new and unifying concept, which means a claim for monetary relief, whether at common law, in equity, or under an enactment. This replaces the haphazard approach taken by the 1950s Act, which sets out different limitation periods for different courses of action. The limitation period for almost all claims will be 6 years after the act or omission on which the claim is based. There are exceptions or modifications to this period in cases of minority or incapacity, or if there has been an acknowledgement of liability, part performance, or fraud. 3-year late knowledge period is being introduced because there might be circumstances where people don't realize they have a course of action. Currently, the limitation period for most claims runs from the date the course of action accrued, namely the date on which all the elements necessary to establish the claim first came together. This has been very contentious and ambiguous. Under this bill, for most claims, the start date will be the date when the act or omission on which the claim is based occurred. The bill provides that the limitation defence can't be used in cases of child sex abuse, no matter how much time has elapsed since the abuse took place. There is currently no statutory limitation period for claims under the New Zealand Bill of Rights Act. This bill rectifies this situation, bringing the New Zealand Bill of Rights Act under the definition of money claims and the 6-year limit. There are two other issues I wish to revisit at this bill's third reading. While Labour agrees that most of the bill, we disagree with the long stop period provisions. The bill provides for a long stop period for 15 years for most cases, but only 10 years for Building Act cases. I acknowledge the contributions made by the Honourable David Parker last night on this particular issue. I believe it should be 15 years for all claims. Owners of houses with latent defects should have just as long to bring the claim as those with other claims. The second matter is related to a Supreme Court case I cited earlier at the bill's first reading. The case is Commerce Commission and Carter Holt Harvey Limited. The brief background of that case is as follows. In October 2002, the Commerce Commission started an investigation relating to misgrading of timber prior to November 2003. And in August 2005, the Commission brought proceedings under the Fair Trading Act in the District Court. Carter Holt Harvey pleaded guilty and was fined $900,000. In October 2006, the Commerce Commission brought civil proceedings in the High Court under Fair Trading Act, seeking compensation for end users of the timber and competitors of the company. Carter Holt Harvey applied to have the High Court proceedings struck out on the grounds that it was statute barred under Section 43, subsection 5 of the Fair Trading Act, having been brought more than 3 years after the date on which the loss or damage was discovered or ought reasonably to have been discovered by the Commission. The strikeout application was unsuccessful in the High Court, but succeeded in the Court of Appeal. In the Supreme Court, the decision of the Court of Appeal was reversed. What is relevant to this particular bill, according to Bell Galley, is in respect of reasonable discoverability. As drafted, the bill does not define knowledge, nor does it specify the degree of knowledge required before a claimant is taken to know or ought reasonably to know the specified facts. So it is therefore likely that, I quote, in the absence of amendments to this bill, the Supreme Court's decision in the Carter-Holt-Harvey case will influence the application of the limitation bill once enacted, end quote. I asked the Attorney General to take a call at the committee of the full House stage last night to shed some light on this particular point. It is a bit disappointing that the Attorney General appeared not to have taken a call on that particular point. So back to the Limitation Act. Nevertheless, the bill appears to succeed in its goals of enhancing clarity as to the applicable limitation period. However, in relation to equitable claims, such clarity has arguably come at the expense of equity's history freedom from limitation periods. I agree to what Russell McVeigh stated in its opinion, that while the concept of the late knowledge period may prevent injustices to claimants, the bill cannot, of course, prescribe a code for assessing whether, in a particular case, a plaintiff knew or ought to have known the necessary facts. I guess, necessary facts, that will always be a task for the courts and one of increased significance under the new regime. So I guess that would have answered to some extent the question I posted last night to the Attorney General. Having said that, I hope with the bill being passed into law, the surgery required is no longer beyond the proper province of the courts. Thank you, Mr. Speaker.
Thank you, Parada.